Hello everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. In this video, we're going to talk about Trump admin announces major immigration change from New Year's Eve. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. The Trump administration has introduced a sweeping regulatory change that could significantly narrow access to asylum in the United States. Under a new rule published in the Federal Register, migrants may now be denied asylum if they are deemed to pose a public health risk. The regulation, which takes effect Wednesday, expands the government's authority to block asylum claims on the basis of communicable disease concerns. What the new rule does, at its core, the regulation empowers immigration officials to prevent certain migrants from advancing in the asylum process if they are considered a potential threat to public health. Previously, many applicants were entitled to proceed to a full asylum merits hearing. Under the new framework, officials may screen out cases at an earlier stage, particularly in situations that fall into legal or factual gray areas. Legal experts warn that this shift gives officers broader discretion to close cases before they reach immigration judges. Morgan Bailey, a partner at Mayer Brown and a former senior Department of Homeland Security official, noted that migrants who once would have had their claims fully heard may now be excluded much sooner in the process. Why this matters? This rule adds another powerful tool to the administration's broader immigration enforcement strategy, particularly at the U.S.-Mexico border. It also echoes policies used during the early months of the COVID-19 pandemic, when the Trump administration relied on Title 42 Public Health Authority to rapidly expel migrants in the name of limiting virus transmission. By linking asylum eligibility to public health assessments, the regulation blends immigration law with disease control policy, raising concerns among advocates about fairness, transparency, and due process. Key provisions to know: the rule was jointly issued by DHS and the Department of Justice and includes revised guidance on credible fear. Screening is a preliminary evaluation that determines whether an asylum seeker may pursue a full claim. Under the regulation, the administration may designate specific countries or regions experiencing communicable disease outbreaks and use those designations when deciding asylum and withholding of removal claims. This approach could result in narrower interpretations of what constitutes credible fear. Officers may be encouraged to resolve cases more quickly, even when applicants have incomplete narratives or delayed supporting evidence. Importantly, the rule does not create an automatic asylum ban and does not retroactively affect individuals who have already been granted protection, a rule with a long history. Originally issued in December 2020, the regulation faced repeated delays and revisions. Subsequent amendments by DHS and DOJ complicated its implementation, prompting the current action, which removes certain technical changes while preserving the core public health provisions. Although the Biden administration postponed the rule's effective date 5 times, it ultimately did not revoke it, leaving the framework intact. Broader immigration context. This development comes amid a series of restrictive immigration measures under the Trump administration, including halts on green card and citizenship applications for immigrants from certain countries, tighter eligibility standards, and reduced refugee admissions. Refugee intake is set to be capped at 7,500 for fiscal year 2026. Since Trump's return to the White House in January, unlawful crossings at the southern border have reportedly dropped to historic lows. What happens next? The regulation formally takes effect on December 31st, setting the stage for stricter asylum screenings shaped by public health considerations and signaling a continued hardline approach to immigration policy. New U.S. rule to bar asylum over security. Health risks takes effect from December 3rd. Who are to be affected? The U.S. administration has formally unveiled a new regulation that allows asylum claims to be denied on the basis of public health risks. Although the framework for this rule was originally developed during the COVID-19 pandemic in 2020 under President Donald Trump's first term, its implementation was postponed. The Department of Homeland Security has now confirmed that the revised and finalized 2025 rule will take effect on December 31st, 2025. Background and evolution of the rule. The original draft was designed in response to the unprecedented global health emergency caused by COVID-19. Over time, however, certain pandemic-specific provisions became outdated. According to DHS, these elements have been removed in the final version. At the same time, the core public health safeguards have been retained, allowing authorities to evaluate whether an individual poses a security risk to the United States during a declared public health emergency. What the final rule allows. Under the updated regulation, individuals may be found ineligible for asylum or withholding of removal if they are deemed a danger to national security due to serious public health concerns. This includes scenarios involving future pandemics, disease outbreaks, or cases where an individual has a severe communicable disease and refuses treatment. Importantly, the rule itself is rooted in immigration and asylum law, rather than public health law. Impact in the absence of a pandemic. When no public health emergency exists, the rule has no immediate operational effect. However, it equips the administration with a legal mechanism that can be activated swiftly if a health crisis emerges. In this sense, it functions as a contingency tool rather than an ongoing restriction. Policy context and government rationale. During the COVID-19 pandemic, the Trump administration relied on Title 42 to expel migrants at the border. DHS now emphasizes that this new rule serves a different legal purpose. Officials have stated that the regulation aligns with broader efforts to ensure that individuals who could threaten U.S. security are not granted asylum protections. 21 immigration judges fired in San Francisco, many reportedly without explanation. Immigration advocates are raising serious concerns following a sweeping wave of immigration judge terminations across the United States, with San Francisco emerging as one of the hardest-hit regions. Reports indicate that more than 100 immigration judges have been dismissed nationwide in recent months, including at least 21 who serve the San Francisco Bay Area. These abrupt removals are already reshaping the immigration court system and threaten to extend case backlogs from months into multiple years. Judges removed without explanation. Several of the dismissed judges say they were fired without cause or justification. Jeremiah Johnson, a former immigration judge who served for 8 years, described receiving a brief email notifying him of his termination just days before Thanksgiving. According to Johnson, he was one of 5 judges removed on the same day. "I was deeply disappointed," Johnson said. "I had active cases, a clear responsibility, and a strong understanding of the gravity of my role. There was no explanation, no reasoning, just a message saying my service had ended. For doing my job," says former judge. When asked why he believed he was fired, Johnson offered a blunt response: "For performing his duties as the law requires." Immigration judges preside over removal proceedings, and Johnson argues that removing judges en masse undermines a legal framework meant to ensure due process. Johnson is now part of a group of former judges formally challenging the federal government's actions, asserting that the dismissals violate statutory protections intended to preserve judicial independence within the immigration court system. Questions of judicial independence. Immigration judges are employees of the Department of Justice and are appointed by the Attorney General. However, Johnson emphasized that the law grants them independent decision-making authority. That independence is not symbolic. It is supposed to protect judges from political pressure and arbitrary termination, he said. Legal scholars echo these concerns. They warn that undermining judicial independence risks eroding trust in the immigration system and compromising fair hearings for immigrants facing life-altering decisions. A strategy behind the firings? Professor Bill Hing, a law and migration studies expert at the University of San Francisco, believes the firings may reflect a broader enforcement strategy. He suggests that reducing the number of judges could increase delays, making immigrants more vulnerable. One theory is that prolonged delays discourage people from pursuing their cases, Hing explained. Extended detention, uncertainty, and repeated court postponements can pressure individuals to abandon their legal rights altogether. Justice Department pushes back. In response to criticism, the Department of Justice defended its actions, stating that it is working to restore integrity to the immigration system after what it described as years of lax enforcement under the previous administration. The department maintains that reforms are necessary to correct systemic issues. San Francisco backlogs set to worsen. With reportedly only 4 immigration judges remaining in San Francisco, Experts fear the local backlog will escalate dramatically. Cases that once took months to resolve may now be delayed for years, leaving families in prolonged legal limbo. A final word from the bench. Despite his dismissal, Johnson says he remains at peace, confident that he upheld the law. He recalls the final words he spoke to a family seeking asylum in his courtroom. "Welcome to the United States." Now, Johnson is calling on Congress to scrutinize the Attorney General's actions and demand a clear plan to ensure undocumented immigrants retain meaningful access to their day in court. U.S. to hike immigration fees from January as Trump tightens visa and green card rules. Beginning January 1st, 2026, the United States will introduce higher fees for select immigration applications following an inflation-linked adjustment announced by U.S. Citizenship and Immigration Services. The revision applies to specific immigration benefits governed under H.R. 1 and reflects inflation measured between July 2024 and July 2025. USCIS has made it clear that applications postmarked on or after the effective date must include the updated fees or risk outright rejection. The Department of Homeland Security has also signaled that these fees will be reviewed and revised annually as mandated by law. While some immigration-related charges will rise, others will remain unchanged under the current Federal Register notice. Any future adjustments, including potential changes to the immigration parole fee, will be announced separately. Understanding asylum eligibility and status. To qualify for asylum in the United States, individuals must be physically present in the country and demonstrate a credible fear of persecution in their home nation. This fear must be tied to race, religion, nationality, political opinion, or membership in a particular social group. Applicants are required to show either evidence of past persecution or a well-founded fear of future harm. Asylum status itself does not carry an expiration date and can only be revoked under narrowly defined circumstances by USCIS. Asylees are entitled to several benefits comparable to those available to refugees, although they are excluded from the Federal Reception and Placement Program. Eligible asylees may later apply for lawful permanent residence by filing Form I for 85 to adjust their status. Increased scrutiny for green card applicants. From 2026 onward, green card applicants and existing permanent residents from 19 countries flagged as security sensitive will be subject to enhanced screening procedures. USCIS has confirmed that the administration has ordered a comprehensive review of permanent residence approvals involving nationals from these countries, signaling a stricter posture toward long-term immigration benefits. New entry bans and travel restrictions. A major shift in U.S. travel policy will also take effect on January 1st, 2026. The administration will enforce a full entry ban on citizens from 12 countries, including Afghanistan, Iran, Somalia, Sudan, and Yemen. In addition, partial entry restrictions will be imposed on nationals from 7 other countries, such as Cuba, Venezuela, and Turkmenistan, limiting the types of visas available to them. Workplace enforcement takes center stage. Immigration enforcement is expected to expand significantly into workplaces during 2026. Authorities plan to increase audits, inspections, and enforcement actions, which could result in higher arrest numbers. Economic analysts caution that replacing workers detained during enforcement operations may raise labor costs, adding pressure to inflation control efforts ahead of critical congressional elections. Massive funding boost for border agencies. Under a comprehensive spending package passed earlier this year, Immigration and Customs Enforcement and U.S. Border Patrol will receive an additional $170 billion in funding through September 2029. This marks a dramatic increase compared to their combined annual budgets of roughly $19 billion, underscoring the administration's long-term commitment to border and interior enforcement. Political fallout and administration response. Public approval of President Trump's immigration approach has declined, with approval ratings falling from 50% earlier in the year to 41% by mid-December, according to Reuters. Despite this dip, the administration continues to defend its hardline stance, arguing that aggressive enforcement and record deportations are necessary to address years of elevated illegal immigration under the previous administration.